Well, everybody, welcome. My name is Jacqueline Harani, and I am the current secretary of the New York City Bar Association Senior Lawyers Committee. And we are an intergenerational committee that's dedicated to bringing attention to the issues that affect not only senior lawyers, lawyers in transition, but ways that we can give back to the community and connect the younger generation of lawyers coming in. So I'm very excited for today's panel. This is our Emerging Legal Paradigms panel. This is the first event in what we hope will be an ongoing series throughout this fall and the new year in 2021 to bring attention to issues of what's on the cutting edge of law, where are we headed, and how can we all have more meaningful careers as attorneys. So today's panel will be talking about the fact that as the adversarial tradition has made way for more cooperative techniques. You might have heard of alternative dispute resolution, collaborative divorce, drug courts, mediation, problem-solving courts, restorative justice, integrative law. All of these things are helping to lead lawyers to increasingly turn to peacemaking, problem-solving, and healing rather than winning, arguing, and punishing. The panel of three experts we have today are going to discuss the emergence of an international trend toward new legal paradigms, the reasons for it, and the legal theories behind it. So I'm happy to introduce our moderator. We're honored to have the Honorable Maria Arias, a family court judge in New York County. Peter Gabel is one of our speakers, who is the author of several books, The Desire for Mutual Recognition, Social Movements and the Dissolution of the False Self, and Another Way of Seeing, Essays on Transforming Law, Politics, and Culture. He's the editor-at-large at Tikkun magazine, co-founder of the Critical Legal Studies movement and the Project for Integrating Spirituality, Law, and Politics, also known as PISLAP. Marjorie Silver is our second panelist here. She is the director of the third panelist here. She is the director of externships and professor of law at Touro College Law Center. She's the editor and contributing author to a great book, Transforming Justice, Lawyers and the Practice of Law, and The Effective Assistance of Counsel, Practicing Law as a Healing Profession. Nanette Shore is our third panelist here, coming from the Bronx Legal Services as Education Law Unit Director. And she's also co-founder of the Project for Integrating Spirituality, Law, and Politics, PISLAP. So with that, Judge Arias, I'll turn it over to you.
Hello, everyone, and welcome. I am reaching you from my chambers here at the New York Family Court. And I am really happy and excited that these three colleagues have asked me to join them today on this exciting panel. The order in which the panelists will speak will be Peter will go first, then Nanette, and then Marjorie. And the three of them will give their presentation. And after that, we will open up for questions and answer and discussion so we can share and discuss with you further the ideas that we are going to be putting forward. Each panelist is going to speak approximately about 12 minutes, give or take. So without further ado, I'm going to turn it over to Peter and we will begin. Welcome.
Peter, we need you to unmute first. Wait. There you go.
Am I unmuted? Okay.
There you go.
I think Kevin and I were muting and unmuting each other. So greetings, listeners and fellow panelists, participants. Well, if any of you saw the presidential debate last night, I guess you could say we saw a good argument against the excesses of the adversary system. Jacqueline, I think you summarized it as winning, arguing, and there was a third.
Punishing.
Punishing. All three were so present that it was difficult for me to stay in the room. That may have been true for some of you also. And, you know, just imagine what it would have been like to have a conversation in which two or more people gathered together and discussed the opportunity of providing health care to each other, resolutions to caring for the earth and climate change problems, eliminating poverty, ways that we can address and heal the legacy of racism in the culture. Imagine a sincere conversation about that on television between two people who were going to be spokespeople for the community, leaders, who were debating and discussing the best way to go and bringing their whole emotional beings to the discussion toward an idealistic end. What happened last night was just so far from that as to be indescribable in a way, and it is partly the result of an adversarial legal and political culture which pits people against each other and fosters this kind of mutual antagonism, argument, winning, and punishing, in Jacqueline's words. And what the three of us, Marjorie, Nanette, and I are, and Maria also, are all part of the project for integrating spirituality, law, and politics, whose aspiration is to create a new legal culture, a different kind of legal culture, that we call it integrating spirituality, law, and politics, because we want, on the spiritual side, our aspiration is to elevate consciousness and bring people to a higher and more sensitive, more open-hearted awareness of each other in the world. And on the political side, it's in a way, it's not really possible only through meditation or yoga or private practices to achieve that greater sense of awareness and openness. It's necessary for the whole social environment to be transformed so as to foster that kind of sense of community and mutuality and awareness of the sacredness of our common life. So law, you know, is the last place you might have thought that these things would be united, but our aspiration is we feel strongly that the legal arena is a central place in the culture, that it is meant to be the embodiment of the ideal of justice, and that the realization of justice involves integrating spirituality and social change into a public forum in which disputes between people and important policies are discussed and implemented and disseminated. The problem that we face is that we are in a culture, a legal culture. We have inherited a legal culture that kind of fits around us like an envelope that sees the world very differently from the way that I just described it. As an outgrowth of the liberal revolutions of the 18th century, there were many great achievements in fostering the liberty of the individual from group oppression. And I think, you know, we could acknowledge that our legal system, in assuring not only freedom of speech and freedom of assembly, but also maximizing individual liberty where possible, is, you know, was a great contribution to the history of human beings in many ways. But it's had a problem, it's become a problem, and that problem is that it pictures the world. It has created a picture of the world and of society as a collection of what I call disconnected monads, everyone pursuing his or her own identity without bonds between us that are being affirmed, illuminated, and validated. So I did my little PowerPoint here just to show this picture of the world of American law. This is the society that's embedded in legal doctrine and legal thought. The vision of society is of disconnected monads, everyone pursuing his or her private destiny. So if you think of the law of contracts, contracts is about socially separated individuals, each seeking the benefit of his or her bargain. Torts is about a very limited notion of caring for each other, so that we can't pull a chair out from under the other person who's sitting down at the dinner table. We can't smash into their car. We can't create dangerous conditions that could harm people. But there's nothing in tort law about caring for the other, about feeling a sense of responsibility for the other person's well-being. The homeless person we step over on the street, there's no inherent bond that legal culture and this culture of justice is calling upon us to recognize in our existing legal system. Property law is about putting boundaries around plots of land, really quite imaginary boundaries that give you the right to exclude other people. But it's not about the collective stewardship for the earth or for our collective environment. And the Constitution itself, which was a great document, a very important document, as I said, it emphasizes and makes great strides forward in fostering individual liberty, but there's nothing in it about creating community, about concern for the other, caring for one another. A few words in the preamble evoke that, or in the Declaration of Independence, but there's nothing profoundly emphasized about the importance of creating a world in which we can fully see each other's humanity and care for one another and the earth around us. So, or corporations, to take another very practical example, the existing law of corporations pictures the corporation as something run by managers in which discrete investors who are totally separated from one another put their money in with the goal of maximizing their short-term profits. And of course, that's the duty of corporate managers. But the potential of these collective forms of intervention in the world for a higher purpose are not fostered, are not emphasized, are not conceived of as part of the corporate model. So that's one aspect of the individualism and the disconnectedness of the picture of the world conveyed through law. And when we make legal arguments, we transmit this world picture without being aware of it. The learning of the law, the internalization of these doctrines, and then the speaking of legal doctrine in public spaces keeps recreating that picture of the world as a world of socially separated individuals or disconnected monads. I've already commented on the adversary system, that the process of law where you demonize the other party and you aggrandize your own position. As you learn from the first days in law school when you write your first legal memo, you learn how to accentuate what's good about your own case and minimize what's good about your so-called opponent's case. And in many cases, it really does involve aggrandizing your client and demonizing the other. I think of the just terrible letters I've received from lawyers when I've gotten involved in lawsuits that reflect that tone, that attitude, and that content. And finally, and very importantly, law as it's currently practiced and thought, legal reasoning, separates the analytical aspect of the mind from the openness of the heart. It disconnects the analytical and the intuitive, so that people in the legal arena make arguments and try to win with arguments. But there is no presence in these cultural arenas for empathy, compassion. We don't learn this in school. We don't teach it to the next generation of lawyers, how to think about cases in a way most likely to achieve Martin Luther King's definition of justice, which is justice as love correcting that which revolts against love. That's how King described justice. So what PISLAP is about, what our group is about, is creating a legal organization that's saying, the liberal revolutions of 250 years ago were very important. We recognize their value. We want to preserve their value, but we also want to go beyond it to the creation of a legal culture that affirms the dignity and the beauty of the other person and that seeks resolutions of human problems that connect us deeply. I'll stop there. What happens now?
Hello, everyone. Wonderful to be with you, and really a very unique event during this time of pandemic when we're all trying to bring our creative energy and our ability to connect with others very much to the fore. So I'm really, really pleased to be on this, sharing this panel with Jacqueline and Judge Arias and Peter Gabel and Marjorie Silver. In my working life, I'm a supervising attorney for the education law practice at Bronx Legal Services, which is a nonprofit organization serving the low-income Bronx community with free legal services. And our mission is to fight poverty and to seek justice, racial justice, economic justice. While I'm going to be speaking about my work here, I'm speaking in the panel in my personal capacity rather than on behalf of the organization. So Peter spoke just now to us of the aspiration for our legal culture to reflect our connection to and our care for each other, both as individuals, as a culture, and to create the vision that Martin Luther King spoke of. And I've always loved that statement, love, justice is love, correcting that which revolts against love. So I wanted in my time here with you now to tell you about some initiatives that I've been involved in or connected to, which have as their common thread the goal of seeking to bring more of law's potential for healing relationships and strengthening community to the foreground. So the first I want to talk about is a mediation project that I'm involved in. So our family law practice in legal services has as its primary focus representing survivors of domestic violence and supporting victims of crime. And this involves appearing in court on behalf of survivors in high conflict contested legal proceedings, seeking protective orders, child custody and support, and divorce. And in these cases, the court system is sometimes used to further batter victims. And proceedings are lengthy and they're a big drain on both parties and lawyers. The low-income community that we represent at Legal Services frequently calls with family law issues that take place in a different kind of context. There's conflict, but not abuse. We give advice, but we've really felt the limitations in our ability to assist. So we decided to start a program to offer divorce mediation to the low-income community, partnering with Antoinette Del Ruel of the New York Legal Assistance Group, who had already created a mediation program using the understanding-based model developed by Jack Himmelstein and Gary Friedman for the Center of Understanding and Conflict. We developed a partnership between NILAG and Legal Services to offer mediation to our community. We were drawn to work that left parties more deeply invested in the outcome, which often involves long-term co-parenting. Parties could achieve, through mediation, a greater understanding of each other's feelings, goals, and aspirations, and use that to communicate as their children grew older and the divorce proceeding was well behind them. And lawyers who were involved in mediation who otherwise primarily represent clients in contested adversarial cases could get more insight into their own judgments and biases and how they affect the people that they represent. So in our mediation model, we have two attorneys co-mediating, and each of the parties of both the husband and the wife or the partners are matched with a pro bono consulting lawyer who advises them but does not go to court with them. When the mediation ends with what we hope is a signed agreement, an uncontested divorce is filed by the mediator, and the mediation agreement becomes the final divorce judgment. In addition to this partnership, and an unexpected benefit of it has been our regular mediation team meetings, where we spend quite a bit of time sharing, role-playing, and processing the insights that we have and addressing the challenges of working with our clients. These are always deep conversations where people make themselves vulnerable as they struggle to figure out how to shift dynamics of relationships and reach meaningful outcomes. And we're also very often dealing with individuals who have experienced trauma in their lives, or we're dealing with pro se opposing parties. So there are many challenges that people face in their day-to-day practice. And the values that mediation foregrounds of empathy, compassion, self-awareness, and skills at connecting are recognized in the mediation context as core skills of lawyering and important part of our legal voice. So I want to give you a second example as well of how we're bringing some of these principles that Peter spoke of into our legal practice. A part of the law practice that I'm very involved in is our education law work, which focuses on advocating for low-income students with disabilities and their parents in the public schools, both individually and on policy issues that affect that community. School reopening and the challenges of remote learning, as well as the disparate impact of both COVID-19 and remote learning on the low-income communities, and particularly on the communities of color that we represent, is very much on our minds and in the forefront of our advocacy. Our representation in education law has required us to become involved in addressing the experiences that our clients face in their lives and in school. We seek to address what people know as the school to prison pipeline, in which many of our clients that we represent find themselves. And that involves, students getting suspended, having inadequate supports in school, having contact with the police, and becoming disconnected and alienated from the educational system, from their own aspirations, and from learning. To fully represent these clients not only requires representing them in their cases that may grow out of those situations, such as special education or suspension, but involves looking at deeper and more long-term and enduring solutions for them. And one of those is something that I wanted to tell you about, which is our Healing-Centered Schools initiative. Since 2018, a fellow in our office, Katrina Feldkamp, brought together and led the formation of a Healing-Centered Schools working group in the Bronx. The group zeroed in on the impact of trauma on students, both trauma experienced in school and in students' daily lives, both individually through their own experience and just the grinding impact of the poverty that they live with day to day. The Healing Center Schools group highlights the goals of helping young people feel safe, valued, and loved in their schools, and seeks to help schools align their own goals and their practices with that aspiration. And so the group developed a very powerful platform for change over a 2-year period called the Roadmap for Healing-Centered Schools. And that roadmap was written by and for Bronx communities. It creates a framework for schools creating transformation teams and step-by-step practices, which include school staff, parents, and students, to transform school cultures into nurturing, nourishing, supportive environments. The term Healing-Centered Schools was developed by Professor Sean Jitwright, who wrote a book on the subject and was the keynote speaker this past summer at our virtual town hall, in which we unrolled and unveiled the Healing-Centered Schools initiative. And the roadmap has actually been cited by the New York City Department of Education in its recent rollout of a learning bridge model for social emotional learning. And this group, this Healing-Centered group, which grows out of our, in part out of our work at Bronx Legal Services, has now organized into an outreach committee that connects with individual schools and supports them in implementing the roadmap, and work advocating with the Department of Education. So it's an example of the law, and it is all grounded in legal rights and the legal needs of students, but guiding advocacy and a vision that will address the individual problems of our clients. The third model I wanted to talk with you about is child support reform. So in the Current Lawyer of the Conscious Lawyer e-magazine, which I think we'll be sharing a link with you of later, and that magazine was jointly developed with PISLAP and the editor of The Conscious Lawyer, there is a piece by attorney Ross Brockway of the Georgia Justice Project in Atlanta, Georgia, called Family Restoration After Prison. And that piece highlights Ross's work with his client Timothy, who was released after a long period of incarceration with a $55,000 child support debt, which accrued from his inability to earn money and make payments while in prison. In Timothy's case, the debt triggered an automatic suspension of Timothy's driver's license as required by federal law. As Ross points out in his piece, driving with a suspended license is one of the most frequent criminal charges in the US and a common employment barrier. And Timothy could also face time in jail for civil contempt or child abandonment. But in this situation, the mother of Timothy's children had hoped that after Timothy's release from jail that he could assume some of the parenting responsibility that she had shouldered during his incarceration. She wanted to waive the support debt and instead have Timothy assume custodial responsibility for the children and co-parent with them. Through Ross's advocacy and the holistic legal representation at the Georgia Justice Project, which PISLAP has always been very connected to, Timothy and his children's mother drafted a consent agreement halting enforcement of the past due support, obtaining reinstatement of Timothy's license, and working out a plan for going forward. And at PISLAP, we thought about Ross's experience with Timothy, and we actually had a panel discussion about the problems and the struggles of low-income parents facing child support debt. And we talked with Professor Ann Friedman of Rutgers, Judge Bruce Peterson of Minneapolis, who developed a co-parenting court. And we took a look at the question of how we can really think about advocating for ways in which the cycle of poverty could be addressed in the child support context and make co-parenting more likely, more possible. And so we advocated for co-parenting training and the involvement of parents in developing support agreements. So what do these three models have in common? The Healing-Centered Schools Initiative, the kind of holistic child support advocacy that Ross is involved in, and the work I spoke about of our mediation project. A few things. So one is feeling connected to our clients, relating to our work as not only being advocates for individual clients, but for the communities that those clients are a part of, because we can't really fully address their individual conditions unless we address the conditions of those community. And we seek to understand what our clients' lives are like in the communities that they live in, and become aware as well of our own biases and judgments. And in those ways, advocate for clients as whole people rather than just as individuals with specific legal problems. And we seek as well to use all the pathways of change so that law is genuinely activated as a healing influence. We see the limitations in the courtroom arena as well as the potential for it. And we focus our attention on pathways for systemic change that incorporate connection and community. We know the law, we know how to advocate for our clients' rights, but we also give value and weight to the ways in which we can foster healing and integrate communal and healing changes into the remedies we seek. So I'll stop there and turn it over to Marjorie Silver.
Thank you, Nanette, and thank you for inviting me to join you on this. I'm really happy to be with what is now 58 participants on this call. So I am going to share my screen because I have a PowerPoint a little more developed than Peter's. Whoops, except it's at the wrong spot right now. I will bring it up to the beginning. Here's the roadmap of for my brief remarks. First of all, I'm going to talk about how I came to join Peter, Nanette, and some other amazing people in PISLAP. I'm going to talk a little bit about the book that emerged from that, and some of the distinctive features of the book, which includes personal journeys of many of the contributors, and a little more, Peter spoke to this, but a little more about what spirituality's got to do with it. And then give some examples of some emerging and emerged processes that fall within this umbrella that has many names: integrative law, is certainly one of them. And that includes, I'll talk a little bit about collaborative law and practices. Jacqueline referred to that, as well as restorative justice and practices, and treatment, also known as problem-solving courts. And then at the end, I have a slide with a lot of contact information, but before we got started, it was determined that I could put all that information in the chat that you will have at the end of this presentation. So, how I came to PISLAP. For a very long time, I had been involved with a school of jurisprudence known as therapeutic jurisprudence. And the basic premise is that law and legal actors can have positive therapeutic impact on the stakeholders involved, or it can have anti-therapeutic and negative impact. And to the extent consistent with other rights, our system of law should try and maximize those positive impacts and minimize the negative impacts. And it was out of that that my first book emerged. And then somewhere along the line, actually through a common acquaintance, I met Nanette. And Nanette invited me to join this gathering in 2011 of a group of people that were part of this project for integrating spirituality, law, and politics. And I discovered, let me back up a moment. My first book, both my books are anthologies. I long ago decided I didn't have a whole book in me, but I knew some amazing people. My first book was mostly contributions by legal educators. But when I went to that PISLAP retreat in New York City in 2011, I discovered all these amazing people who were actually practicing in the ways that therapeutic jurisprudence and I had talked about law should happen. And one of the people I met was Stu Webb, who in fact was the originator of collaborative law. I'll say a little bit more about that in a bit. He's someone I had admired for so long. And I met people doing all other kinds of work that fell within this umbrella. And I decided by Sunday of that weekend that my next book project was going to emerge out of the work that PISLAP members were doing in the real world. I also decided then to propose, and I got approved, a dedicated experiential seminar course to offer at Turo, where I teach, that showcased this kind of work. So this is the book that emerged from that orientation. And it came out in 2017, exactly a decade after my first book, and quite a few years after I first decided that I was going to write the book. And just to give you an idea, not only for shameless self-promotion, but also to give you an idea of the breadth of processes that fall within this umbrella. I'll just touch on the organization of the book. So part one is just one chapter. It's called The Vision, and you may not be surprised to know that Peter Gabel was the author of that chapter. Part two is Transforming Criminal and Juvenile Justice. And it features the Georgia Justice Project that Nanette just referred to, that reimagines the lawyer-client relationship. It also includes reimagining and restoring justice towards a truth and reconciliation process. And I'll talk a little bit more about restorative justice in a bit. Part three was healing civil conflict. And I'll talk about collaborative law as a paradigm for that in a moment. Part 4 was transforming the rule of law. Part 5 was about transforming legal education, to which I contributed a chapter, as well as some colleagues from other schools. Part 6, transforming the courtroom. That featured a chapter by Bruce Peterson, who Peter mentioned earlier, and who has himself presided over problem-solving courts. And part 7, transforming community law practice, which features a chapter by Nanette. And finally, this hasn't been, well, I mean, it's been alluded to in Peter's talk, part 8, transforming the earth. Our one international contributor who contributed a chapter called Voices from Mother Earth, Talks with Activists and Earth Lawyers, and someone who continues to do amazing work to try and protect the environment on an international scale. So 2 features of the book that I want to highlight. Sorry, the T is missing from there. One is personal journeys. I invited each of the contributing authors, didn't require it, but invited them to consider to start off their chapters with their stories of how they started practicing law in a traditional adversarial model, and how they ended up moving into this more relational healing model of practice. And then there's a part of the introduction called What Spirituality Got to Do with It. I have some amazing colleagues and friends who have done great law reform work and continue to do so, who don't consider themselves spiritual people at all. And so, in part, in honor of them, and in fact, I currently have students who didn't understand at first what spirituality had to do with legal education or practicing law. So I just want to share 2 short quotes from David Hall, who was a former dean and law professor at Northeastern Law School and has for a long time now been president of the University of the Virgin Islands, and wrote a book called The Spiritual Revitalization of the Legal Profession. Spirituality in its purest sense, wrote Hall, is a mirror that points always at the persons holding it, challenging them to live at their highest level of existence and urging them to love that which exists on the other side of the mirror. And then I love this quote, which is from someone else, not well known. Spirituality is a lot like health. We all have health. We may have good health or poor health, but it's something we can't avoid having. The same is true of spirituality. Every human being is a spiritual being. The question is not whether we have spirituality, but whether the spirituality we have is a negative one that leads to isolation and self-destruction, or one that is more positive and life-giving. And that's what inspired me. I was born into a Reformed Jewish family, but have not been a, quote, practicing Jew for a long, long time. I do have a meditation practice. I don't consider myself a Buddhist, but I'm informed by Buddhist philosophy. And that's much of what spirituality had to do with my own journey. Just to give a little more about some emerging and emerged processes, Jacqueline referred to a whole bunch of them, and I imagine there's a range of knowledge among the audience as to what these are. So I just want to mention 3. One is collaborative practices. I mentioned Stu Webb a moment ago. Stu Webb is the originator of collaborative law. He was a traditional divorce lawyer in Minneapolis, Minnesota. And in the 1980s, he was so burned out and so fed up with the damage that the adversarial system in general and divorce litigation in particular did to families and children, that he was ready to quit. But instead he had a brilliant idea. And that idea was to become a settlement lawyer and to persuade other matrimonial attorneys to join him in what in 1990 he declared as collaborative law, and advertised himself as a collaborative lawyer. And what's special about this process, although there are various forms of it that have emerged out of it, not all consistent with this, is that each party to the divorce has their own attorney. And they sign a four-way agreement. And what's unique about this agreement is that they will do everything to be open and honest and focused on the children when there are children, but focused on the well-being of all involved, and do everything they can to settle the case, to come to a mutually acceptable agreement. And if they cannot, then they'll step aside, and these parties will have to get other counsel to represent them in court. We have a relatively new dean at Toro, and she was a matrimonial litigator in Florida at the time when collaborative law was, there was a fad about it, and everyone was advertising themselves as collaborative lawyers. And she inherited all these cases when collaborative law was done poorly. So as with so many of these practices, when not done well, they can harm people. And I think that was the case in her experience and the experience of other collaborative lawyers that I know. So that's the major process of collaborative law, which has improved the lives not only of the parties to the divorce, but to the lawyers doing this work, because they're able to do relational healing work. So talked about that. Restorative justice practices take a lot of forms. And if any of you have children in New York City schools, you may be aware that it's becoming something that is used frequently to stop the school to prison pipeline, or the suspension and kicking students out of school that frequently ends up on a criminal, they end up in a criminal path. Restorative justice operates on the individual, the interpersonal, and the systemic levels. And how that happens is that, I just realized I can't see Jacqueline if she holds up that 3-minute sign. Now I can. How that happens on the individual, interpersonal, is in victim offender dialogues, which is one form of it. On the larger interpersonal level, in circle processes, where all the stakeholders, to everyone who's been affected by whatever transgression has occurred, whether that's in a school situation or involving a criminal situation, all have a voice, a respectful voice, in talking about either what led the, quote, offender, though I don't especially like using that term, to commit the offense involved, and what the impact was on the individuals or the communities against whom it was asserted. Circle practices are being used widely now, especially I'm aware of in New York City. There are more and more organizations practicing restorative justice. And then on the systemic level, I referred briefly to a chapter in the book. The authors are Afanya Davis and Jonathan Sharer. And it's about healing the wounds of the racial injustice that we've inherited from the days of slavery, and that are ever so in the forefront of our minds, especially this summer. by healing those wounds through a process like what they did in South Africa, through a truth and reconciliation process. And so all of these fall under the umbrella of restorative justice. Some people reject the word restorative because it sounds like we want to go back to something. And in fact, in many ways, especially the truth and reconciliation process is really going forward to a new relational healing society that hasn't existed, as Peter so well explained. And finally, treatment and problem-solving courts. My guess is that most of you are familiar with these, but they exist throughout the country now, in all 50 states, and take many forms. There's an amazing mental health court in Brooklyn, the first of its kind in the country, that I had the privilege to sit in on many years ago. There's an amazing community court in Red Hook, Brooklyn, the Red Hook Community Justice Center. There are drug courts for the first kinds of treatment courts, and followed by mental health courts, veterans courts, which have been cropping up all over the country in recent years, sex trafficking courts. We have several in Central Islip, which is where my law school, Toro, is located. And they are focused on not punishment again, but on solving the underlying problems that brought the individuals into the justice system in the first place. So those are just some examples of the amazing kinds of practices and approaches that apparently this committee is going to focus on throughout the year, which I think is incredibly exciting. So we're going into questions. The last slide I have, if any of you prefer to just take a picture of that instead of copying the chat, but the chat will be available to you. Please go ahead. I'll leave it up there for a moment and turn it back to Judge Arias to field the questions.
Okay, thank you to each of you for sharing. I have 2 questions, and please, others of you, if you have questions, please put them in the Q&A box, but I'll get us started. So I'm gonna answer the first, I'm gonna read out the first question that I see here. And it says, how do we shift the paradigm demon? Okay, let me put on my glasses, that will help. How do we shift the paradigm, demon aggrandize, when people fear not listening to their legal guide? Don't we need people to choose a better way? How do we create that revolution? Peter, you gotta unmute.
Okay, I'm unmuting. All right, I'll respond first, which is actually, this is a little bit like gradually cracking open an egg. I don't know if that's a viable metaphor, but the key way to create this change is by actually doing it in various places where people who thought it was impossible suddenly see that it's possible. The Georgia Justice Project, which is in Atlanta, which Nanette spoke about, they form lifetime contracts with their clients, meaning that when they represent clients, this is criminal defense practice for the most part, not exclusively, but when they represent clients, those clients become a part of the community of the firm. And in the case of Timothy, to use the example that Nanette talked about in the Ross Brockway child support case, the thing that worked that was so transformative was that Timothy actually became part of the Georgia Justice Project community. He could drop by there after he got out of prison. He could go visit these lawyers who brought him into a sense of appreciation, of recognition, of affirmation, which was so significant to his sense of self-worth that led him to go out and work with them to get a job. I've forgotten at the moment what job it was, but he got a job. He worked out the resolution with his co-partner, who he had been deeply alienated from, because the law firm provided that container. So the thing about it is these things seem impossible until we start to model them. And then because we are speaking to needs that exist in everyone, because everyone longs for something other than that presidential screaming match that we saw last night. They long for the presence of idealism, the presence of open-heartedness and caring. It's an attractor once we create these different models. It's hard in the beginning, and then eventually it spreads and succeeds. I think it will succeed. I remember the old model took 400 years to build, the liberal model, with all its virtues and limitations. So it doesn't have to happen tomorrow.
Nanette or Marjorie, do either of you want to respond to that question, or should I go to a next question? Next question? Okay. I'm a traditionally trained litigator with an expertise in women's rights. I'm used to the us versus them model and have been comfortable with that in the past. What role is there for an advocate like me in this more spiritual collaborative model? Excellent.
Happy, to start addressing that, which is come learn more about a process that isn't adversarial for achieving what you are hoping to achieve. Because whether we're talking about restorative justice or whether we're talking about collaborative law, when we don't see lawyers representing clients on the other side as the enemy, all kinds of possibilities can open up. I mean, Nanette talked about her mediation work as well. There are so many other ways to handle these kinds of conflicts. And I think it starts with your investigating them further. Come join PISLAP.
I want to take a little response there too. I spent 20 years representing battered women, advocating on battered women's behalf, and really very, very focused around, the rights of women who were survivors of domestic violence, and that being my only lens. And I mean, I feel like I gained a lot from doing that, but there's also a lot I've learned from practicing in a different way. And honestly, many of the clients I worked with, they still, it's interesting because they saw the abusive partner. I mean, that wasn't all of who that person was. So there was that part, but then sometimes they were also good with their children, or there were happy moments too. And actually the people I worked with, they helped me to embrace the respondents and the opponent as a whole, that the person maybe had some behaviors that weren't okay, but that there were all these other parts of that person, and how do we relate to that in a different way? So it's possible.
And maybe just one thing to add to what Marjorie and Maria said is that, I think like in our mediation project that I mentioned, all the practitioners virtually are currently representing survivors of domestic violence at the same time that they're also doing mediation on a part-time basis. And of course, that's a big shift, in terms of mindset back and forth. But I know that people really, really value what they do in mediation and feel that it helps them go back to the family court situation and be deeper, better, more connected lawyers in the way that they that they do the work. So that's a lot of versatility that you have to go back and forth in that way. But on the other hand, the healing-centered models can give you lenses, as Marie was discussing, that I think can be very helpful, even in more traditional types of legal situations. And unfortunately, mediation is really not available to people who have experienced, survivors of domestic violence. We don't take cases of that kind because of the power imbalances, but there are elements of mediation that are so helpful to people involved in domestic violence who would actually yearn for a way of having a dialogue with the other partner, abusive though they may be.
Let me unmute myself. Okay, I'm going to go to another question. This was a long one, so pay attention. I see an underlying feminine. Oh, do you know what that is, Jacqueline?
Theme.
Themes, okay. I see an underlying themes in all of these paradigms. I fully support this approach, but since I came to law later in life and came from an academic background, I believe that law students who enter law school straight from college have no ability to relate to people or communities and see law in pinpoint cases unrelated to real life. I propose a major change in legal education, that no one should enter law school without experience in the real world, working for at least a year at almost anything, so that future lawyers can know themselves and experience actual life. I taught my children that the only person you always have to live with is yourself, and you can't deal with or relate to others until you know who you actually are, the spirituality portion. Would you agree that this can address at least part of the problem of the aggressiveness of litigation and promote collaboration?
I'm happy to jump in here as well. I think taking a gap year is virtually always a good idea. I don't think that will solve the problem. I think having real life experience always helps. But the problem, and something I've written about for decades, the problem is with traditional legal education. Because we start out with the case method that reduces people to names and issues that create rules of law. And what we really need is students having experience with real people and an exposure to these alternative ways to practice law. And that is something, that I have tried to do. I did it when I taught what used to be called civil procedure, and I persuaded the faculty to make that course civil dispute resolution and procedure, so that I could introduce other processes for resolving controversies. Unfortunately, my colleagues teaching civil procedure were not expansive in terms of teaching anything other than the rules of litigation. There are some law schools that have done better than my own, I must admit. In CUNY, where Judge Arias used to teach, is certainly one of them. And yeah, I think it would make a big difference if this was promoted as these were promoted as essential values at the beginning of legal education.
Peter?
Yes, I think it's a good idea. The year that you described, the greater exposure to the world, but legal education itself, as Marjorie was saying, is a deeply conditioning process, the way that it currently operates. The use of you're immediately thrown into contracts torts, property, a bunch of rules that you don't know anything about, like the things I talked about in the opening talk. You don't know that there's a worldview embedded in that you may or may not agree with. You don't know that you might want a world to be cooperative and loving, but you wouldn't get any sense that that's even conceivable because you're just in the middle of the rules of, you know, what do you need for a valid offer, and is there consideration, and, or, you know, the elements of something or other. And the elements are themselves conveyors, subtle conveyors of a worldview. So there needs to be a greater, and also the professor that you, initially you're intimidated, and then you come to identify with the professor, and then you come to join the, you know, you become the master instead of the slave, and the conditioning process is all takes good human beings and absorbs them into the role. Not that the role is bad, it's just limited. And so we have had discussions within PISLAP about different things that we can do to transform legal education. So that 22-year-olds like me, who when I went to law school at 22, I mean, it was just a rat race to catch up with itself, which I didn't connect deeply to at all. It took me practically a lifetime to figure out what happened to me there. So what I'm saying is we have had discussions in PISLAP on, you know, some people do some moment of silence before beginning their classes. Rhonda McGee does that, or maybe Marjorie does that. Meditative moments. Some people, which is, you know, frightening in the beginning, but good for you, Marjorie, to, you know, you're going to show your students it can be done. They don't have to panic. And the, you know, Nanette and I have done we did one conference at Fordham where we very slowly read the facts of a case instead of rushing through them. Two men were on either side of a strip mine, which gouges the earth out from a mountainside in Pennsylvania. And one of them prodded the other to jump in and joked with him, said he wouldn't do it. And then the other person did it, and he drowned. And had 2 children and a wife that he left behind. And I actually called the wife, who was very old by the time I found her in the phone book. And anyway, this is the case of a famous case where there's no duty to rescue in tort law, Yania versus Began, that everybody studies in torts. But you don't study that this is about human beings, that these are, you know, what do we think about this dynamic that was occurring around a strip mine, or strip mining itself, or what the culture of all that is. So what I'm saying about all this is that there are ways of more slowly going through the facts of cases and bringing their human elements out. There are ways of trying to figure out resolutions and remedies that go beyond simply deciding who won and who lost and who gets the money damages. That's the creative way of gradually transforming legal education, so that the indoctrination process that the questioner described doesn't occur so much, or at least it's challenged.
Just to add one other piece to what Marjorie and Peter were saying, just in my organization, something we've been doing for quite a while, and I really feel is important, is having law interns work with us during the year. Even though they're in school, they're taking courses in some of the traditional ways that Peter was describing, but they're actually living the experience of working with clients, both individually and, you know, they're part of the Healing Centered Schools work and helping to, you know, bring change in various contexts. And so they get fully absorbed into the encounter and the experience of creating community with clients, of representing them, of connecting to them and their families. So it's something that they then bring with them into their experience in school. Of course, there's clinical legal education as well, which does that. But that whole model of externships, which I know, you know, Marjorie is involved in, and I have been in the past, it's very powerful, and it's a good antidote to some of the issues that have been raised about some of the constriction in legal education, which is itself evolving in some of the ways we've been talking about.
What contributions might those of us in the mental health profession make to this effort at shifting the paradigm towards relational healing? What a fabulous question. Who wants to respond?
I'll start. First of all, a little bit more about collaborative divorce law is I mentioned the four-way agreement between the clients and their attorneys. But in most cases, sometimes it's a requirement, there's also a mental health professional who, just one, not on each side, who looks out for the emotional, psychological, mental issues that may be present, certainly impact on children, but also on the parties themselves. So that's, one way that mental health professionals can get involved. The other that I'm thinking is I collaborate with Dean Susan Brooks from Drexel University, who was a social worker before she went to law school. And a lot of her writing and writing we've done together has focused on how family systems operate and how that paradigm can be integrated into legal practice. So I'd invite you to also join PISLAP and meet some of the people who are involved in that process, and also find out more about therapeutic jurisprudence, because not only are many lawyers participants in therapeutic jurisprudence, there are many mental health practitioners who are as well, frequently involved in criminology, but other areas as well.
I just want to, Lynette, go ahead. Well, I just wanted to briefly say that in the family law context, mental health professionals are just so helpful. I mean, many of the people in the family court have just dealt with so much trauma and many intergenerational trauma. And I find that mental health professional can be so helpful. Frequently, there are attorneys who work in collaboration with a mental health professional around how they present the case, how they work with their client. And it can be really wonderful because also the courtroom can re-traumatize some of the things. And so it can be really hard for litigants to be in the courtroom, and that those collaborations can frequently be really helpful. And Nanette wanted to say one more thing. And I have to say we have a number of questions, so.
Oh, okay, I'll move it quickly. And just a small piece to add, which is to what Maria just said, which is that, interdisciplinary collaboration and partnering between social workers and professionals in mental health is really critical, I know, to our advocacy and, helping clients get through these very difficult and challenging legal situations. And it's a much more holistic way of approaching client needs, because there's so much that's going on inside, and mental health professionals can be invaluable. So I just wanted to add that.
Can you speak a bit more to how you address disparity in power between the parties, especially with one of the parties needing to be transformed as an institution, a school or workplace, etc.? Are the methods you promote suited to institutional change, or do you think that they are necessarily based on development of mutual understanding between individuals? Are there any resources on using these paradigms for institutional change? And I think that this question is coming from a CUNY alum, and I just want to say hi. So nice that you're here with us. Beautiful. Peter, I was thinking you might want to address that. about the power dynamics. Anybody want to take that? You want me to read the question again?
I'm sorry, I was having trouble with my mute button.
Oh, okay.
Well, you know, institutions are not frozen things. They are lattice works of relationships. And so if you're trying to change an institution, you have to figure out where can I enter into this situation to influence someone, some people, and begin to create a new consciousness within the institution. Certainly, you know, I mean, Maria, you know this, you're a judge, you're presiding over a very important institution on a daily basis. And I know that you do try to bring a higher awareness and a deeper sensitivity to your work in the most forbidding of all contexts, the courtroom. And, you know, you are a judge. So I think you could partly answer that by some things that I know that you have tried to do. I don't know if you need to hang around us more often to remember that or not, but no, I know from things you've said, you know, ways that you've tried to create pauses, allow reflection in the courtroom, change the way people speak in your courtroom. And of course, this is perhaps a lawyer who's litigating with institutions, who's raised the question, I'm not sure, which is a slightly different, somewhat different situation. But I'm saying all these contexts, if you believe that what we're describing are human needs that are universally shared, then in all these contexts, it is possible to make interventions that awaken that human part of the community and break through the traditional role-bound part that emphasizes separation. So, Maria, do you feel like saying anything about your court and what you try to do there?
I could, but I just want to say that I do think that as I'm reading the question, it's talking about sort of when you're working with an individual and you're up against an institution, and so how do you engage this in that way? And the other piece of the question that I think would be important is if any of you have anything to offer is if there's any resources on using these paradigms for institutional change. And then let me just kind of talk a little bit about me in the courtroom. So I tried tons of things. Definitely, you know, when everybody was talking about that pause at the beginning of the, you know, silence at the beginning of the class, I absolutely use that. When things get heated, I just, you know, slow everything up and try to, you know, and make everybody, okay, take a breath, and I may not say those words, but I definitely move towards trying to bring that into the courtroom. So we slow things down. Every opportunity I get to model or to do something like, you know, I'll just give you one example where someone's referring to a parent and they just keep referring to the mother or the father. And so if there's something good in what the person share, you know, I acknowledge that, but then I also say, you know, this is Miss So-and-so, or this is Mr. So-and-so. And so in the courtroom, I want you to refer to them in that way. In a very respectful way, I really try to acknowledge the hard work that all the different players involved in the situation are doing. And so I do try to find opportunities to see, you know, to seek a healing way of approaching whatever is before me, and to see, well, what are the needs of the different people involved, and how might we be able to meet them and addressing that. So and with all of that, it's still a very challenging place every moment. So anything, yes. Nanette.
Just one other thing on the whole question of institutional change, which is that just using the example that I mentioned in my talk about the Healing Centered Schools Initiative, one of the things that we found is when we were advocating for restorative justice and restorative practices as a way of addressing suspensions for individual students in school. And as Marjorie mentioned, the New York City school system is starting to really integrate restorative practices and restorative justice. But one of the things, the feedback that was coming back to us from students and their parents was that it was kind of piecemeal, that when restorative justice was just, you know, you're doing a circle around a suspension, but the whole school culture is not a healing environment, you can't really have a good, you know, a strong restorative justice circle. So I do think like changing the larger institutional culture and making that broader change is an integral part of bringing about individual change. So I'm going to add that.
Yeah, I think that's a really important point. The only thing I want to add to it is that I'm not an expert on changing institutions, but any change, institutions are just composed of people. And it's a matter of creating relationships with people who have the power to make the change. If the large institution is committed to be adversarial in litigation or otherwise, there's very little change that you can accomplish. But if you're part of that institution and you have ways of communicating with people so that, like Annette said, actually what Maria said, so that they feel heard and valued and therefore more open to listening to your ideas, I think that creates possibilities for change. I know I have a whole bunch of books in my other home that might be relevant to this. So if you want to reach out to me, if this is a question relevant to something you're working on, I'm happy to recommend some of those books where there's more expertise than I have.
My name is Sophia Sharma, and I am a newly admitted attorney in the state of New York. I come from a small town in India. I chose this profession because I want to bring change and help in making this world a better place. I recently started my own law practice as well to do the best I can to help people. My question is, I am a newbie when it comes to law practice as well as this country. Law schools don't prepare you much for the real life cases. I would like to know what would be your advice and recommendations for a newly admitted attorney. Also, any resources, books, video you may recommend for shaping our career. Thank you. Appreciate your time and guidance.
Jacqueline, there's a Young Lawyers Committee at the City Bar, isn't there?
Yes.
Maybe you can speak for more to that if you know.
Yeah, we'll put some contact info on this question. I think everybody will be able to see the answers if anybody else would like some resources. So any of the panelists, if you name out some things, I'll type out the answers, but definitely connect with the City Bar, and you can connect with me directly at legallyunconventional@gmail.com. I'll put that in there too.
Also, join PISLAP, and we'll write back to you. My email's on there. Nanette and Marjorie live in New York. Join us, and we'll try to support you. We care about the same things you do.
I'm in New York, so I mean the courts are closed now because of COVID-19, but they're open courts. So when the courts are reopened, I'm in the New York Family Court, and if you ever want to visit, please reach out. Okay, so there's one question, which actually I read the story too, and I think this is beautiful. Can you comment on the recent New York Times article by a Regis students where the school decided to work on the roots of racism and not get rid of the bad apples? Did you guys read this story? It's a story of a young man, and at his school, I don't know if I'm getting this exactly right, but there was a conflict. Yeah, actually, there was something racist that occurred from another student to him. And the school dealt with it with kind of a restorative practice where there was, speaking with everybody involved, engaging. This young man got to talk to, this was a friend who then said some racist thing. I believe the person maybe used the N-word, and I don't know if there were other things involved. But there was this healing that occurred between him and his friend, as well as the entire school community got involved in addressing it. It was a beautiful example.
I just wanted to say, I think that that is a beautiful example. And there are many situations where these lawsuits, or where it's done through the formal process at the institution, that further aggravates the antagonism. Whereas this circle process that you're describing at this public school is the opposite. Frequently there are explosions on campuses that, if some leadership had that kind of visionary approach to resolving it, would make a huge difference in building the wisdom of the whole place, transforming the institution as a whole.
There's 2 questions left. Let me read them. And we still have 9 minutes, so hopefully we can get to them both. I have repeatedly seen spouses who are victims of abuse depend on adversarial attorneys as champions and protectors. Given the system, most lawyers are prone to fail such expectations in the long term. But where the other spouse stubbornly refuses to back off from abuse, not in the majority of cases, isn't a good adversarial attorney necessary, at least in the short term? Does a more spiritually oriented attorney abandon that role?
Nanette, that's you, I think.
I was just unmuting myself. I can start, but perhaps Maria has a few thoughts too. So I think that one has to, I think where abuse is going on, and there's not a backing off from it, that being an assertive, powerful advocate on behalf of your client is very important. And in a sense, that's true to a spiritual approach as well, because you've got to be, being a spiritual attorney is also about standing up for justice. And so it's a question of what the quality of that justice is and how to shape it. And so I don't think that that there's really a necessary, because I think you're bringing up the larger question of whether there's a dichotomy between being a zealous advocate, being a forceful advocate, and having a more healing and community-centered approach to the law. And I think one has to struggle to bring the two together, but I actually think they're integrally connected. The more connected one is as a lawyer to an understanding of the deeper forces affecting your client's situation, and some clarity about how to address those, both in the case and more broadly, the more powerful you can be in your advocacy. I agree. It's a challenge to all of us, and particularly in domestic abuse situations, it raises it to a very high level, that challenge. But I do think that the two approaches are not opposed. There's a unity between them.
The one thing I would add is that you always say no to abuse, and you always say no to abusive behavior, but you remember that the abusive behavior is not all of who that person is. And you try to hold that person in some, with some love. A lot of times abusive people were abused themselves. And so not to justify it, because I hold both things. And actually, once I learned that was really freeing. No matter what happened to you in this moment, you still have to do the right thing. That's your responsibility as a human being to yourself and to everybody else. So everything that happened to you is not an excuse to now behave inappropriately and to carry that abuse forward. So you always say no to abuse, but you don't say no to the human being. And you try to see what is there something around that human being that can still, that you can still hold. And, whatever you give and offer, you may not see the fruits there, but who knows, that gets carried on. So that's my response around that. We have one more question. I am an advice limited scope attorney with a nonprofit and used to litigate family law cases. What can the New York City Family Court do to improve litigants' experience with the litigation process if these alternative paths to justice aren't available to them? Ensuring they are heard, e.g., ensuring they are heard, understand what is happening, treat it with respect. I know jurist caseloads are great, especially now, but I just feel the atmosphere of being in court is one of great discomfort and stress, especially when you don't have a lawyer. That is so true. I guess I'll start. So I make every effort I possibly can. I mean, I look at people, I try to slow things up. When people are having strong emotions, I give a moment for some space to have the emotion. I try to acknowledge the emotion. I do everything I can in the courtroom. Now, I also have other players. So I have staff that sometimes I'm managing. So I'm working with them, trying to get them to also behave in the way, that would be helpful. And as you're saying, it's hard because it is a very high volume court. I find though, like for example, when I'm on intake and I have a high volume of cases, I just share with people the truth about the moment. I say, Miss So-and-so, I know you have a lot you want to tell me, but I just need you to know I'm on intake. I have a lot of cases I have to handle. So I only have a few minutes today to hear you. Usually the case is going to come back to me. So I always say, on the next day, I'm not going to be on intake and I'll be able to hear more. So I need to focus. And even within that, I still give space, so I may ask the questions I want to ask, but I still give space. I say, is there something really important that I haven't asked you about that you feel it's important for me to know right now so I can address what your needs are in this moment? So I try to still give that, add that. But it's very challenging. Nanette. Nanette, do you want to say something to that question too?
Sorry. I think you got it, Maria. I don't have a lot to add though. Thank you. That was a great answer.
I just want to add before I flag for us wrapping up because we're coming close to 2:30, but I did put a link in the chat to all of the participants about an article on human-centered design in courthouses. And that may not be something that each of us individually can do in our interactions in court or with our clients, but something to look into and consider for those who are interested in how we can start to shift and transform the experiences within these institutions. And I recommend anybody who's interested to click the 3 little dots at the bottom right of chat, and you'll have something that comes up that says Save Chat that will allow you to access these resources later. And also if you click the bottom of the screen Q&A, you should be able to see answered questions where we've typed out answers publicly, and those have some links or contacts as well.
Could I just put in one more plug for this edition of The Conscious Lawyer, which also has an article on transforming the design of the courtroom in it. But it also, that will connect you up to PISLAP more if you look at The Conscious Lawyer.
And there is a link in the chat to that PDF of the latest issue, but I'll paste that again for easy reference for everybody. And I will wrap up with some things about the Senior Lawyers Committee, but I want to give you all a chance for any final statements and let Judge Arias close the panel out.
Well, actually, Jacqueline, I was going to ask you if you could email the thing you said about the institution. I know it's in the chat, but.
Absolutely.
Well, I just want to say this has been so wonderful. Your questions, all of you, your questions have been so engaging. And I hope all of you will join PISLAP in some future events and activities. We are really spending time grappling with all these issues so we can transform the law profession and the legal practice, and how we can, in a more humane and connected way, really create the beloved community. So thank you all.
Oh, do we have Peter drop off already?
You laughed already.
Okay, well, that's okay, because the only things I have to add is to let everybody who's still with us know the Senior Lawyers Committee is having a few events coming up you might be interested in. On Thursday, November 12th in the evening from 6:15 p.m. to 8:15 p.m. We have our Lawyers in Transition panel. And, oh, Peter's back, awesome.
I don't know what happened to me. But...
on Friday, November 13th from 1 to 2:30 in the afternoon, we're going to have an incredible program with Kim Wright, How Can I Be a Lawyer and Still Be Me? And that's going to be a Q&A. Feel free to reach out to us to submit your questions anonymously, but we'll be able to do that during the program as well. About your specific situations and how we can help guide and give some more examples and resources, as we've started to do in this panel, of how you can have a more fulfilling legal career. So keep an eye on the New York City Bar calendar. If you'd like to sign up for our newsletter that we'll be sending out for the Senior Lawyers Committee, we will send that out. If you just send me a message, I'll put my contact again in the chat. And feel free to find me on LinkedIn as well. I'm sure all of our panelists are more than happy to connect with you on there if they do use that. But everybody is very open and friendly here and would love to connect people to all of these transformational practices. So the emails are in the chat and we'd love to hear from you. All right, thank you, everybody.